President of the Lincoln Club. We are a PAC, Political Action Committee, and have been for probably about 15 years. Several points I want to make in regards to this complaint. We're required to keep our records for 2 years, so that would be 23 and 24, 2023 and 2024. And in those years, 2023, the tickets were $60 a piece, and in 2024, they were $75 a piece. So a table would have been $480 or $600, depending on the year. But as has been indicated in the article in Herald Bulletin, which I was aware and others are too, that for 50 years approximately, filings of the CFA4 for committees, for candidates, have filed as events. You put it all together and put it in. Many times, most of the time, to my understanding and knowledge, those were ticketed events under $100. So technically, they could have been filed under unitemized. We, the Lincoln Club, have always filed them as an event under itemized, just so we were being open as to where the money was and what the event was. With a ticket at $60 or $75, they're paid by individuals. Sometimes the candidate will get people to sit at their table, they'll collect them from them and give them to us, or write a check from their own committee, and that would seem to me to be a convenience.
Well, it's already on there now, but I thought you said we could view it.
You can, but not on the...
What difference do it make whether it's on the phone or whether I'm looking at it?
Because then it becomes a record that you take out of here and it's not allowed.
Now, do you have a statute I can read and get the clarity on that?
It's called the Russ Willis statute.
They're saying I can't.
In regards to whether or not this has to be, whether or not it rises to the level of a level 6 felony. The statute, which is Indiana Code 3-14-113, says a person who knowingly files a report required by IC 39, which is fraudulent, commits a level 6 felony.
Correct.
And so your evidence that these reports were filed knowingly fraudulent is what?
My evidence is that the Republican chair, who holds himself out to be an expert, tells people that he knows how to file the report, will help them file the report, sits on this election board, and is the one who votes on people who don't file reports properly, should know how to file a report.
Okay. So it's just based upon what he should know, basically.
It's based upon his knowledge and experience.
Okay.
Anthony Emery.
Well, there was, but in the other cases, the other years, you tendered other reports where their donations were shown to be made, and I didn't see that for the year 2020.
Unfortunately, I don't have reports for every single person that would have donated in 2020 to the Lincoln Club. May have been people that didn't even file or were a candidate for office that year. So I wouldn't have those reports.
So you don't have evidence as to that particular year?
I do have evidence. I've given it to you.
What is that?
I don't have any additional reports for that.
If
Mr. Willis would like to come up, be sworn in and testify, with regards to the fact that that lump sum was all less than $100 donations, I suppose he could do that.
Okay, so you're not conceding that you don't have evidence?
I am not.
2020. All right. So the issue becomes the findings that we have do include the year 2020. So is there a motion to be made as to the findings? I mean, the law, as I understand it, is once the findings of a deficient report are made, that notice has to be given to the candidate or to the committee who filed the report that they have a 5-day grace period to cure the defects. You agree with that, don't you?
I do not. I first off want to provide some filings that I have for you.
Oh, this is just your appearance.
Correct.
We can have the witnesses who testified on the 18th put under oath now and ask them if they testified. I'll let Mr. Graham handle it precisely how that's handled. So if you were a witness at the 18th and you were here, would you please come forward and we'll put you under oath. Mrs. Callahan, you were a witness, I believe.
I'll just defer to my attorney.
No.
You swear your testimony today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please come to the microphone so we can make the record. Mr. Wells, do you remember your testimony that you gave before this body on December 18th?
Yes, sir.
Do you recall, was that testimony completely truthful?
Yes, sir.
Nothing truthful.
All right. And if there were other witnesses who testified on the 18th, if they'd come forward and be sworn in, we'd appreciate it.
Lorraine, you want her to do that?
She's on that.
Okay, is that good enough?
Okay, good. And I think those were the only two witnesses who testified, correct?
Correct.
All right, thank you. All right, is there anything else that the board wants to, in considering these additional documents, these issues still before the board is, was there a deficient filing of the reports that are alleged in the complaint that has been filed? In my opinion, that's clear that there were deficiencies, and I'm prepared to make such a finding. That's my understanding that the state law requires us to give notice to the individual or the committee in this case that filed the deficient report, and that the deficiencies are to be cured within 5 days. Or at least there is an opportunity for the deficiencies to be cured within 5 days. And that's what I think the board should do at this point in time. And that is, I believe, embodied within the findings. We've got enough. I think we're ready to make the ruling on this.
I want to make an objection, so it's not waived.
Okay, make your objection, please. It'll be noted on the record.
Indiana
We
statute.
haven't even done this yet, but yeah.
Indiana statute requires, if you believe that there may have been a violation, that you refer this to a prosecutor.
But there's not a violation until the 5 days have gone by for the cure, aren't you? You disagree with the opportunity for the filers of the deficient reports to make the 5 day grace period. Is that right? You think that statute doesn't exist, or what?
I think that she did not file a complaint under that statute.
Well, that's what the statute requires. So that's embodied within the findings of fact that continued to us by our counsel. And if there's a motion to approve that, stand ready to have the board consider it. If not, I'll make that motion myself.
Can you speak up a little bit?
Motion at this time?
Motion to approve that the person with the violation of the defective report should have 5 days to cure the defect, correct?
Right, and a finding that there were deficiencies as to the reports as listed within the proposed findings given to us by our counsel, which were the defective reports for years 2020, 2021, 2022, 2023, and 2024.
Okay. I did talk to the state on this, and yes, there should be an opportunity when there is a defective report for the person who filed the report that they have 5 days to cure that report, and I will make that motion.
I'll second.
All right, there's a motion and a second to approve.
Just for the record, board, are we adopting the proposed findings?
Yes, these would be supported by the findings as prepared by our counsel, Jeffrey Graham.
Do I need to reword?
Is it the board's contention?
Do I need to reword?
Is it the board's contention that Russ has not received notice of defective reports yet?
It is going to be a formal notice that he has 5 days to cure.
And our findings direct our attorney to provide that notice.
So since August, this board has not provided him notice that his
That is
filings
correct.
were defective.
There you go. Thank you.
All right, there's a motion before the board to accept the findings as tendered by our counsel. All those in favor of the motion signify by the voting sign of aye.
Aye.
Aye. Opposed, same sign. The findings of the board will be entered as per the proposed findings tendered by our counsel, Mr. Grant.
In regards to whether or not this has to be, whether or not it rises to the level of a level 6 felony, the statute, which is Indiana Code 3-14-113, says a person who knowingly files a report required by IC-29, which is fraudulent, commits a level 6 felony.
Correct.
And so your evidence that these reports were filed knowingly fraudulent is what?
My evidence is that the Republican chair who holds himself out to be an expert tells people that he knows how to file the report, will help them file the report, sits on this election board, and is the one who votes on people who don't file reports properly, should know how to file a report.
Okay. So it's just based upon what he should know, basically.
It's based upon his knowledge and experience.
Okay.